Hello and welcome back to the Data Privacy Lawyer. My name is Funmi Owolabi and I am the principal attorney. Today's review, we're going to be looking at some AI terms. So the value in looking at the artificial intelligence terms as a privacy firm is to make sure that there's consistency in terms of the processing that is associated with this service and how the artificial intelligence works at an organization, whether it's from the supplier side or the customer side. So let's just take a look. I think it's great that they have a service description here. I'm not familiar with this organization. CBAI, I'm intrigued about what this acronym is for. I think it would be valuable to put all acronyms at the first instance so that a company that is conducting due diligence can know what CB might constitute. I don't know if that's something that they know, or maybe it's community builder, but I can't be sure. That's why it's very important to put description or spell out the full acronym at the beginning of any terms. If a customer is wanting to sign up and they're not familiar with CB, this could mean anything. So that's valuable there. That's not privacy related, but this could be a privacy term. I can't say that for a fact. I'm just saying why I think it's valuable for suppliers to be upfront about that, so that during the due diligence phase, if a potential customer wants to know what terms they're signing up for, they have insight to that prior to any communication with a supplier. So CB AI Assistance provides AI-powered content creation and improvement services for websites through an AI API. Now, I'm familiar with what API is. It's an application programming interface, but if you are not familiar with these acronyms, as part of the due diligence process, you might not be able to understand what this is. Through an AI API proxy service, primarily using OpenAI's AI services, but possibly also others listed below as the backend providers. Let's talk about this from a privacy perspective. So I've seen a couple things already. It looks like it's possible that there's going to be processing by additional third parties outside of your supplier. Now, from a data protection standpoint, we usually refer to those as subprocessors. I'm not familiar with the tool. One thing that I do as a privacy counsel is when clients come and speak to me, they ask me to provide insights related to privacy advisory. I need to be able to understand how your products and services work before I'm able to provide advice about what the law requires, right? So we've got two things. We've got what the law dictates. We've got the geographies and what their definitions are in certain geographies where your products and services are operated. And then we've got how your product works. So when you have a privacy lawyer, they don't just draft, privacy notices. Those notices that we do on the site, that is not the conclusion of a privacy lawyer's work. We look at how your product works and we make sure it has privacy by design. We look at the terms that you're distributing to your customers to make sure that they align with your own privacy practices and the privacy laws. We also take a look at obligations in the geographies where you provide your products and services, because that matters. I've talked about that in almost every single review on this channel. Geography influences how your product operates and what your obligations are, whether it's on the customer side or if it's on the supplier side. The perspective we're looking at this is from a supplier. A supplier is providing the CB AI assistant. The first thing I would do is I would look at the technical specification. How does this work and what do the customers see? Because that will influence the terms. That will influence the terms you should be distributing to your customer. And then it also looks at what the customer can accept. If there are terms that you have that are inconsistent with certain privacy laws, it may be too high of a risk for a customer. Again, every business is trying to sell their products and services. A lot of customers are very intent on making sure that they don't jeopardize their own compliance obligations under the privacy laws, because businesses are becoming more and more aware of the ramifications and the repercussions of not adhering to these privacy legislations. Just a couple of weeks ago, the California Protection Agency for Privacy issued its largest fine to date on an organization whose privacy practices were inconsistent with how it was processing personal data. So it is something important that businesses should take into consideration. All right, you must be at least 13 years old to use our services. If you're under 18, you must have your parent or legal guardian's permission to use the service. Now, why would we have this sentence? From a privacy perspective, we have something called a Children's Online Privacy Protection Act. It is a federal law, and it dictates that if an organization is going to process a child's data and the threshold year that they use under COPPA is 13, it's important to obtain parental consent. Now, you can see here, if you're under the age of 18, what does that tell me as a privacy lawyer? it tells me that we're not just looking at federal privacy legislation associated with a child, we're also looking in other geographies, because other geographies have a different threshold for what constitutes a child. Do you see that? That's why these sentences exist here. Now, I can't say that for sure. I don't know the geographies. We're not provided that during these terms. But I do think it's valuable for organizations to see why certain sentences might appear in terminology. This organization is looking at their privacy compliance. They're looking at what constitutes a child. What would be the repercussions if we don't address this in the terms that we provide to our customers? These are very important sentences. You're responsible for reviewing and publishing AI-generated content, ensuring your rights to publish content and comply with all applicable laws and AI provider restrictions. Now, I would be intrigued from the supplier side to find out what type of responsibilities they constitute complying with all applicable laws. The value in this, again, I talked about geography, is if you're an organization, let's say, for instance, you're headquartered in the European Union, but you process personal data in the District of Columbia belonging to those residents, right? You need to take a look at not just the privacy legislation in the European Union. You need to look at privacy legislation in the District of Columbia. And if you agree to these terms, you are responsible for complying with the applicable laws there. So you wouldn't be able to absolve yourself of responsibility just by using these services. That might not be something that an organization knows when they sign up to the terms, which again is why it's valuable to have privacy counsel to walk you through that. Especially if you are in a heavily regulated industry. In the United States, industries that are regulated heavily usually process sensitive personal data, like the healthcare industry, financial industry, right? As an organization, the responsibility is still placed on you to maintain your own privacy compliance, irrespective of which type of supplier you choose to use. Let's talk about our favorite thing. Again, I think I talked about this at the beginning of this review, but essentially privacy hinges on every single component of the business, whether it's how you operate your own privacy program to what your marketing team does, what your legal team does, what your sales team does. There's personal data in every single aspect of the business. So this is very important for organizations. If you are going to be introducing a vendor who is going to process personal data on your behalf, you need to be able to understand what it is that you're signing up for. You cannot just sign up for any type of term. We process minimal personal data in compliance with Swiss data protection laws. Okay, very good. Now I'm intrigued about this sentence because they've explicitly called out Swiss data protection laws, which could infer that they only have clients in Switzerland, right? I talked at the beginning of this video about geography. Now, in the event that this organization processes the personal data of US residents, they would need to provide assurance to the companies whose personal data that they process that they also are in compliance with those data protection laws if they meet the thresholds. Every geography has its threshold. Swiss data protection laws has its own threshold. US states like California has its own threshold. If this organization is going to process California residents' personal data, they also need to make sure that they are processing minimal personal data in compliance with those data protection laws if this organization meets those thresholds. Now, most times we're not going to see that. Companies not going to say, hey, I've never seen it. I'm intrigued about whether I'll see it going forward into 2026. But generally, the information on where a company provides its products and service, that's something that's an internal document. That's not distributed to customers like the terms. They've mentioned Swiss data protection laws, so I presume that at a minimum, they do have the processing of Swiss residents' personal data. What's not being called out here is US or other European Union geographies. That's something that needs to be decided between the business supplier and their privacy counsel to address data minimization, which is really what is being called out in this sentence here. Server logs, which may include AI API activities for automated performance monitoring, are retained only as required for its required use to provide the service and by Swiss law. Let's talk about this, and this will be the last thing I talk about for this video. Retention is a global privacy concept. In every single geography, you are going to encounter the requirement to retain data only as is required for the purpose. And we can see the purpose here is providing the service. No organization should retain data just because and indefinitely. Those are very problematic in every single privacy legislation that I have encountered. So we can see that they've actually put the retention period not to exceed 6 months. So that's really valuable. The other thing I want to talk about, and I talk about this a lot in my privacy notice reviews, is security obligations and security safeguards. We can see a lot in the United States that security obligations on companies has grown in prominence. Right now we have over 20 data protection laws that are state specific, and each and every one of them addresses the fact that security safeguards need to be put in place. So these sentences don't happen by accident. They're drafted in order for organizations to know what it is that this third party is doing, and to make sure that if a customer is choosing to obtain the services operated by this organization, they have this provision. And this organization is essentially warranting the fact that they implement appropriate security measures. Now, something that I would do if I was negotiating this on behalf of a customer is I would request the security measures, because my customer might have different security measures than those that are addressed in these terms. So during the due diligence phase, it would be valuable to see what the security measures are that they state that they have, and verify those against the security measures that I as a customer have. Make sure that they're aligned. All right, I really hope you enjoyed this particular review. If you have comments or questions, leave a comment below and I'll see you in another one.